I'm very happy to welcome you to this latest event of the SPIN talk series. So I'm Elspeth Van Veeren, an associate professor in global politics in the School of Sociology, Politics and International Studies at the University of Bristol, but also the co-coordinator of SPIN and our chair and host for today. For those of you who are new to us, SPIN is the Secrecy, Power and Ignorance Research Network, a group of academics and artists, principally based in the southwest of the UK and in Wales, though we're expanding to other parts of the globe. And we're all committed to exploring the social, cultural, and political power of unknowing. So this includes supporting research on secrecy, intelligence, conspiracy theories, knowledge and ignorance, and a host of other cognate concepts and issue areas. So today I'm very pleased to welcome Dr. Lydia Morgan, who's a spinster and is from Birmingham Law School. Lydia researches and teaches public law, legal theory, socio-legal theory, and human rights. And she explores the interplay between law and political theory on topics such as national security, counterterrorism, accountability, and conceptions of freedom. Her new project looks specifically at state secrecy, the UK security services, the regulation of investigatory measures, and the responses of liberal theory to contemporary political practices. So we're therefore really pleased to have Lydia share the insights of her latest book project with us today. But before I turn over to our speakers, I'll briefly mention that I'm be monitoring the chat. So if people have questions, even though we'll save some time at the end to sort of have a discussion and answer questions, you can, of course, drop them in the chat function. To say that today's event, of course, will be recorded and then posted to our SPIN YouTube channel with a link circulated via our LinkedIn feed. And to remind you that next week, of course, for Spinsters, we have our regular Research in Progress session. But with a twist. Of course, we've agreed to discuss a classic secrecy reading. This time we're reading Simmel's piece on secrecy and secret societies. And of course, next month in December, we have our second SPIN conference. And the draft program for that is available on our website. And I guess finally, I'll make a plug of our SPIN podcasts, which are now starting to stream. We've got a set of 6 new episodes, so do look out for those. So that's the self-promotion stuff. So I'll turn over now to Lydia, who's going to give her talk.
Hello, thank you so much for having me. I'm just going to see if I can share these slides so that you can see them. Although I wouldn't worry too much about the slides because they are just kind of giving you a brief guide of what I'm talking about. I have already shared with the network more widely. Can you see the slide? Okay.
Yeah, we can.
Great. Okay. I've already shared with you some sample chapters from what I am talking about, or rather some sample excerpts. I didn't want to put you through the 80 or so pages of in-depth law, which comprises one of the chapters. This project it's probably not fair to completely call it a new project. I've been working on this for about 10 years. And also, I am slowly, very slowly creeping towards getting it into a book form. I had hoped when I agreed with Elspeth that I would do this talk, that it would have already been in its book form. But I was much scuppered by the advent of the teaching term and the amount of time it took me to prepare some new material. Oh, okay. Okay, so the book is really focused on trying to make sense of what state secrecy means by looking at law as an object, as an idea, as a kind of sociological phenomenon, and trying to understand the laws and policies that enable it to exist, specifically in the jurisdiction of the UK, but also looking at that to lean into my own academic background a little more about how it might be understood within the liberal democratic frame. So it's kind of pulling on these two different ideas together. It starts with the kind of idea that there is an intuitive sense in which state secrecy is a problem for a liberal democracy, and tries to unpick that by working through a number of different elements. The book overall consists of 8 chapters, which are trying to deal with what my view of the kind of more extensive system of state secrecy that exists in UK law and regulation is, and what that might then mean for different types of liberal theory. So I'm going to try and take you through a few sections of that. There are portions where I'm going to be reading because I have been dealing with teaching counterterrorism, and keeping the two things in my brain at the same time has proved more challenging than it is sometimes when I'm just focused on the research. So the book begins by unpicking the idea that the sort of self-presentation of openness in liberal democracies like the UK is contradicted by the more extensive schemes of state secrecy that often occur, particularly in reference to guarding national security. In so doing, transparency as a value is transformed into a reified, inherently radical, transformed from a reified, inherently radical democratic, political, or legal good into a pragmatic one, leaning on the challenges that transparency leaning into the idea that transparency is an incoherent normative ideal, replete with unachievable practical implications. So this means that, like, the idea of transparency is then tested because it is a far more has far more paucity to it as a principle, in such that it is performative and construed as an edifice disguising the default and ingrained practice of state secrecy. So we see then that this presents this idea of state secrecy as something which is limited and a justifiable exception, which I think is what the common view of state secrecy in particular, rather than secrecy more broadly, is often presented as in some of the literature. In some ways, it is desirable that this kind of secrecy is highly circumscribed and available only in the most exceptional circumstances. But the actuality, the reality of what is happening in the law and regulatory framework, that it's far more extensive in both political practices and legally constituted institutions and behaviours. I suggest in chapter 1 that the narrow focus occurs in part because we tend to focus in law on the Official Secrets Act and their several manifestations, as well as a fair amount of misconstrual of them, and control of information through classification markings, and some of the famous 1980s cases around breach of confidence, such as the Spycatcher litigation, which is a fairly interesting chapter in British history, and also the Blake case in relation to the publication of former spies' memoirs, and the attempt by the British government to restrict that. Whereas the wider view of state secrecy, I propose, means that you have to focus on the subsequent regulation of the security intelligence services, MI5, MI6, and GCHQ, as well as the now growth in clear closed material procedures in civil and criminal actions, and the use of the system of special advocates from its beginnings in the Special Immigration Appeals Commission, also known as SIAC, to hearings related to terrorism prevention and investigation measures, which were the replacement for control orders, which is the term that most people have more familiarity with. And then the ever more complex regulation of investigatory and surveillance powers and intelligence work. Here, in that part of the chapter, I spend quite a lot of time detailing what happens in the two omnibus statutes, as we call them, the Regulation of Investigatory Powers Act 2000 and the Investigatory Powers Act 2016, which was also later amended more recently in 2024 to actually reduce the amount of supervisory control that's contained within it. I spend quite a lot of time unpicking a range of different areas of how these laws develop, looking at them through both their statutory development and also in the changing approach, or rather the reducing approach to supervision under the European Convention of Human Rights, where it is becoming more acceptable to the court, for example, to limit the supervisory control of intrusive warrants, where previously intrusive warrants were seen as a bedrock to constitutional rights safeguards. One example of this, in fact, there are two examples that I'm going to talk you through now. Let me just change my slides. Focuses on the idea of the judicial commissioners that were created in order to proceed through what is known as the double lock warrant for targeted warrants and other surveillance powers. And the other is around the creation of the Investigatory Powers Tribunal. The judicial commissioners, which were touted when they were introduced in 2016 as an accountability in innovation, involve a warrant process for the most intrusive surveillance powers, the ones that are often the kinds that you don't know about, the ones that are facilitating the kinds of surveillance and hacking and tapping of people's communication networks, and generally taking the information from you without your knowledge, either on an individual basis or in the most significantly impacting for rights cases, those that might have a geographical area that is covered, or ones that might cover a particular target grouping. And when you do that, you're also obviously taking in a wider network of people. The judicial commissioners operate under the Investigatory Powers Commissioner, who is intended to be one of the steps of accountability for this kind of intrusive power. But really, it should be regarded as an innovation of a limited gloss on a procedure that has been required through an element of the European Union's Court of Justice in what is known as the Watson case, because it was a case taken forward by Tom Watson at the time, which challenged one of the bases for the temporary act that existed before we had the IPA Act in 2016. Moreover, we can also see that following the revelations of Edward Snowden, that there is a far vaster landscape of government surveillance than such that it is unlikely that the necessities of the Investigatory Powers Act 2016's accountability reforms would be seen. This takes us forward so there's a lot of complicated kind of different interacting case law here, but it takes us forward to a really significant case from the European Court of Human Rights, which was several years and several layers worth of court proceedings called Big Brother Watch. In that ruling, the Grand Chamber found that its existing case law had a similar conclusion to Watson, which indicated that the abuse of bulk interception surveillance powers and the warrants that are enabled on them is in fact so worrying because it's so easy in individual cases and could have such harmful consequences for democratic society as a whole, that in principle, it's desirable to entrust a wider supervisory control to a judge, or to have some sort of judicial control of such warrant processes as we would, which would guarantee then the independence, impartiality and proper procedure, rather than them having signed off by the Home Secretary, which is what previously was happening. But what we have to then look at is whether the signing off that is done by the judicial commissioners through that double lock role, which was required by these two cases, does in fact provide that kind of supervision that was imagined. But really, it's quite difficult to unpick because the language here is particularly misleading, right? They are judicial commissioners in that they had previously held high judicial office, but they are not necessarily sitting judges. And they also don't operate in the same terms of judicial approval that other kinds of warrantry processes would engage. So, for example, if they review the initial authorization in terms of necessity and proportionality, we know that they are engaging through their kinds of human rights analysis. But what often is happening is rather than going through this stronger sense of substantive review and approval processes, the JCs are merely ensuring that the warrants lock has been engaged in its issue and checking that that bolt is secure. And that is because they employ only the principles of what we call judicial review in the legal context, which means that they aren't applying a full merits review. They are only looking for applicable standards. So was this power used by the relevant person within their power to have, as the statutory terms enabling it? Can it be confirmed through the reasonableness of that standard, which is a particularly difficult element of judicial review to uphold? So essentially, there's a far lighter review that is happening here in terms of how we are expecting these judicial commissioners to look at the content of these warrants. And that is before we've even got to the urgency provisions, where the warrants can be issued without prior approval of the judicial commissioners if the necessities of the circumstances demand it. So there is a number of different overlying complicated factors there, and that's before we've even got to the understanding that on the whole, there is a lot of substantial judicial deference in the area of national security. We know that the courts are generally extremely reluctant to question the executive and their decisions on national security, meaning that when we're talking about the kinds of warrants that enable us to gather intelligence and information, largely these are happening through processes that appear to be giving approval, but are often done so in a fairly light touch manner, but perhaps a kind of checkbox manner without necessarily engaging in proper questioning about whether the intrusiveness is justified. The second example that I highlight throughout the chapter looks at how you might then deal with complaints processes in relation to the use of intrusive surveillance and any kind of work of the security services in general. If you wanted to bring a rights-based complaint, this would have to be done through what is called the Investigatory Powers Tribunal, which is a specialist tribunal that doesn't operate within the standard structure of the courts in the UK. It operates behind its own veil of secrecy, and it also becomes clear that it will then legitimise covert and mass surveillance in this way. So taken together, these two ideas effectively covertly legitimize mass surveillance and does so by claiming a level of judicial participation and therefore legitimacy while remaining within the executive structure in a hived off and restricted manner. So there's a lot of different elements here where I kind of draw around the kind of claims about how independence should operate and what that means in terms of the kind of role of scrutiny within liberal democracy. But looking specifically at what happens within the Investigatory Powers Tribunal, I work through how the origins of this tribunal are based in the general inadmissibility of intercepted evidence in court, right? So we can't normally use these types of intercepted evidence in order to use them in criminal trials on the basis that this would contravene most of our understandings of the core precepts of liberal democracy and our ability to make decisions for ourselves. This creates a number of different problems, of course, when the kinds of activity that are being looked at are ones that we would like to be able to prosecute people for those courts, for those particular actions, and also through various civil procedures. And what we've seen then in a range of different courts, both pre and post 9/11, is the development of what is known as closed material procedures, or CMPs, which were originally used largely in administrative procedures such as the Special Immigration Appeals Commission, but then have gradually also been used in processes such as the Investigatory Powers Tribunal. The Investigatory Powers Tribunal itself was established under the regulation of Investigatory Powers Act 2000 and amalgamated the three different existing tribunals that dealt with complaints from the security and intelligence agencies. It is the only forum in which the security and intelligence agencies in which complaints about the intelligence and security agencies can be heard. But they are not necessarily ones which operate in public form. Indeed, its original rules said that it would only operate in closed form, but there was an innovation within the tribunal itself which challenged this and said that it was necessary to comply with the rule of law and open justice to have some sense of open hearings. For much of its existence, the IPT was also its own apex court, as there was no route of appeal to the main court and tribunal framework, even on purely procedural points of law, although this was then changed in 2019 after significant pressure on these kinds of claims and also some relevant work through the European Court of Human Rights. When we look at the detail of how this particular tribunal operates, we can see that it's really undoing and challenging our conception of what open justice and transparency mean. So we only really know about how it operates because the court itself has provided some detail. So we can look to the case of liberty, privacy, number one. There are about 6 cases that are referred to as liberty and privacy. So keeping track of them sometimes is a little bit challenging. And where really what we see is that the secrecy is there in order to enable a complaint process to take place. Secrecy would otherwise mean that we would just outright reject the complaint and not make any complaint process relevant to the security and intelligence services or other kind of intrusive surveillance power. But instead of operating according to the standard procedures such as evidence and disclosure, not only does it operate in largely closed form, it also operates on a particularly curious procedure known as assumed facts. So these provide a hypothetical fact, a hypothetical ruling based on assuming that the facts asserted by the relevant person, the complainant, are true, and makes no claim on the finding of the substance of the complaint itself. So the tribunal constructs this actually quite procedurally odd process where it can hear complaints but not otherwise undermine the principle of neither confirm nor deny. So while we see that the creation of the tribunal and some of its early cases, such as the one that actually overturned that it could never sit in public, we see that this is really a very limited sense of openness and transparency, and that we are now focusing on the kinds of processes that require us to employ oversight and accountability through what Woods, McNamara and Lawrence have recently referred to as trusted intermediaries, people who we must place our public confidence in order to understand whether the system is being true to the principles on which the powers are justified. Through this terrain in Chapter 2 of State Secrecy Law, I will seek to demonstrate that it is populated by institutions that are constructed on secret practices and regulated to such a complexity as to maintain an opacity to their procedures and operations, which have muted the principle and practice of open justice, and focuses on processes which are focused on closure rather than on openness. I suggest that this means that it is not merely that there is a culture of secrecy that pervades the UK political sphere or an indelible aspect, as Richard Crossman had once referred to it, but is in fact an organising principle which is built into the constitutional scaffold. If we take seriously that state secrecy is an organising principle in this way, rather than a discrete element of legal and political practice, a wider range of political and legal principles have to reckon with its force. So far, I argue that the common view doesn't do this sufficiently because it hasn't given us enough content to what the idea means, which is where I move on to working through in Chapter 3 my proposal for how we should understand the concept of state secrecy. This concept, I argue, is in fact one that should be understood as a pluralist concept, which has three overlapping and interacting elements. Working from the overview of the UK's legal and political framework that I give in Chapter 2, I suggest that it can be divided into three categories: esoteric, operational, and efficient. Oh, apologies, clicked onto the wrong thing. Esoteric secrecy is focused on the idea that we have only a number of restricted persons who can participate in certain decision making and therefore have access to restricted material. It maintains a degree of insiderness to large parts of both the executive working and also the legislature's working. And as we have seen with some of the examples I've given, also with the way in which the judiciary is focusing, it is therefore a facet of power which is utilised in order to control. Operational secrecy protects rather the techniques and procedures and investigations that are used by those who need to have them confirmed. So when we see that MI5 need to have some of their ability of how they are undertaking surveillance, the particular techniques that they are using in order to keep watch, that we need not be able to have access to those, otherwise they might be subverted by the practices themselves. In many ways, operational secrecy is the one that has the most logical reason behind it, and it's not nearly as all-encompassing as esoteric state secrecy, although it can be cumulative, where one demand for secrecy creates another, such as how we see in arguments for things like mosaic theory or the extended timelines for closure on access to classified material through the I can't the name of the particular, the Public Records Act, extended to, which is has a 30-year rule, for example, on how much material we can access over time, although we also have various instances in which those rules themselves have also been circumvented. Finally, I argue that we also have a third sense of secrecy called efficient secrecy, which references a far more pragmatic sense in which secret conditions do allow for faster decision making. This obviously has an impact on how we understand things within liberal democracy, but is also really something about the conceptual limits of what transparency could mean. We couldn't possibly know everything about everyone that is happening, even within the government sphere, even if we wanted to. And so we must accept that there are some conceptual limits to our understanding of what we should understand about the government and its work and at various high levels. I take these three conceptions in chapter 3 and move through into chapter 4. Now, much of the book I have written as framed in a kind of cartographic metaphor, which traces conceptual landscapes, providing way markers and overlaying contours to illuminate and corral through a degree of simplification in much the same way that map makers do. So I start in chapter 4 by trying to understand what state secrecy would mean for liberal democracy by tracing back secrecy through some of the liberal democratic theories, tracking through the woods of liberal democratic theory more broadly to try and discover their core principles and consider where there might be friction and rewards in relation to state secrecy as a loose idea, which I then take in later chapters and advance through the very specific spectrum of liberal thought that I have outlined in chapter 3, and take that up, in chapter specific outlines of state secrecy that I have taken and overlay that with the kind of the key facets of liberal thought that I outline in chapter 4. It highlights, for example, that Bentham had a distinct distaste for secrecy. He felt that it was an instrument of conspiracy and ought not to be a system of regular government. He favoured publicity, allowing only very narrow exceptions without publicity, he argued, there is no good permanent government under the auspices of publicity, no evil can continue. Several centuries before, we also know, or rather not several centuries, but a couple of centuries, Kant also viewed secrecy as ethically impermissible. But in his work, we also see that there is a complicated contradiction where he says that while moral politics cannot tolerate secrecy, it itself might be based on a secret, or to borrow Plato's idea, a noble lie, because of the way in which we look at, particularly his example focuses on the idea that the monarchy does not have control around in Parliament in the UK. I take these to suggest that when we look at liberal democracy, we actually find that both elements of it, the liberal theory part and the democratic theory part, is quite brittle as categories, and that they're quite hard to pin down. So we're best to understand them as something that exists on a spectrum. And that spectrum highlights that there are at least 4 main facets that tend to occur in these types of theories, which I have argued are the primacy of the individual, the role of reason, legitimacy and accountability. Nothing terribly controversial there. In order to demonstrate this, I looked at 3 different theorists which were not necessarily chosen because they are most persuasive in the canon of liberal democratic thought, for example, but rather because they showed the full scope of what that spectrum is. So I began with John Locke, and then I moved on to Henry Sidgwick as a representation of utilitarians, particularly useful because of his focus on the consensus of experts idea, which is widely regarded to be deeply epistocratic, and also then later into John Rawls, since one cannot particularly write about liberal democracy without spending a little bit of time talking about John Rawls. So without wanting to skate over what happens in the final parts and the final chapters of the book, where I work through all of these ideas, both from these different theorists and from the conception of state secrecy that I have proposed, I look through what the kind of push and pull of these contradictions are. So what are the contradictions, for example, that happen in liberal democracy about who counts as an individual and whether that has an implication for how we understand the different elements of state secrecy. I also look at what we mean in terms of participation in democracy, what that might mean in terms of our understandings of reason, particularly looking in more detail at the challenges of both epistocratic and plutocratic arguments, which seem to both be able to happily accommodate all the forms of state secrecy, but in so doing seemingly abandon many of the core tenets of both liberalism and democracy. I engage in a lot of theories about the around legitimacy and the purpose of accountability and how these may or may not be achieved by deliberative democratic approaches, for example. I have taken in the arguments of Christina Lafont in her book Participatory Democracy, which suggests that judicial structures, rather than representing a counter-majoritarian problem for deliberative democracy, might in fact be able to participate in them. I argue that while this might work theoretically and in reference to codified constitutions, more like that in the US, state secrecy and amended restricted accountability processes that are seen within tribunals such as the Investigatory Powers Tribunal and more the growth of closed material procedures in concert with the wider judicial deference around national security, when it means that we cannot sustain the judiciary as a fulsome facet of deliberative democracy overall. So having pulled these three ideas together, I find in the conclusion that the result is unsurprisingly a mixed picture. It is surprising that most aspects of liberal democracy, as I have approached it, could accommodate operational secrecy and to some lesser extent efficient secrecy without too much trouble. But all forms of it struggle with esoteric secrecy unless the epistocratic consensus of experts is at the forefront, which means that we are entering into a rather elitist vision of liberal democracy, which does rather do damage to our conception of it overall. And that brings me to the end of what I've said. Thank you.
Marvelous. Sorry. Thank you, Lydia. I was just trying to get the screens all sorted out.
Unmuted.
Okay. So yeah, exactly. So we have some time. I think we've got about 20 minutes then to take sort of questions. We can open it up to discussion to the people in the room as a whole. I mean, I have a few questions, so maybe I'll start there. Oh, I can see though Robert is keen to jump in. So why don't I, rather than abusing the floor, I will turn over to Robert, and then I will subject you to my questions in due course. Go ahead, Robert.
You're still on mute, I think.
Robert's also having, so if Robert doesn't get his sound sorted, which I'm sure you will, then maybe I will jump in. And I think the first question I have is a very self-centered one, in the sense that I know that your project is totally connected or focused on the UK state. But I wondered how much, because I think one of your critiques is really that so much of the literature is on the US landscape. So I was wondering if maybe you could spend a few minutes drawing out a comparison, because those of us who maybe have been reading a lot of the literature may be more familiar with the US case. So would you be able to say a few things while Robert sorts his sound? Would that
I can. I haven't looked at this aspect of it for a couple of years. So you will forgive me if some of it has kind of gone slightly off kilter, though I do think that there are still important things to say. So some of the work that I did was spent looking at how state secrecy is conceptualized in the US, and particularly how it's conceptualized in the law, where there is a far more developed sense of what it means. In fact, there's a whole element of what they mean in terms of executive decision making known as the state secrets privilege, and it is founded on a particular set of case law, which when I looked into it, I found very interesting, because it's actually based on developing a principle from Duncan Campbell Laird, which is a British case, but taking it in a very different direction in terms of how we understand it. So this is one of the cases about somebody who it was about access to information about when somebody had died during their military service, and was kept separate, and was kept, the family were kept out of access to that information on the basis that it would reveal certain things about executive decision making or other parts of the kind of national security state. Now, that then became very fulsomely developed in the US in a context where the regulation of all of their main security structures, so the NSA, the CIA, have always existed to a certain extent in the post-war frame in regulatory structures, right? So their first act was in 1947, for example, whereas so you're seeing already a fairly significant lag between what we're doing in the UK, where we always existed in terms of this in what we call prerogative, right? So we find that there's a particular case about whether members of GCHQ could be part of a trade union in the mid 1980s, called, the case is called GCHQ, which found that national security is par excellence a matter for the executive and not one in which the courts would get involved. So without the statutory form, we're already seeing that state secrecy is far more ingrained in the legal sphere as something that is not available to the kinds of judicial accountability or even the kinds of accountability that we might think as standard within the frame of the separation of powers. However, I do also think that if you look at what's going on in the US, that there's a lot of access to information, a lot of structural information, a lot of what we might call process transparency, which isn't the same as transparency that looks at the detail of what is going on, what the justifications for certain kind of decision making are. There is a point where I was looking at some of the claims that were made around the findings of the 9/11 report, for example, and the 9/11 Commission about the way in which interagency working became a significant challenge to how we understood whether we actually had access to information at all. And I think that fits in part of my framing of efficient secrecy, where the kind of overlaps between those different conceptions. One of the pieces that I had worked through was David Posen's idea of deep and shallow secrecy, which I found that it was useful to a certain extent, but it didn't sufficiently have either enough content on the temporal aspect. So what you do when you can never get access to information, even though time has passed. And also, I thought that it didn't account for all the kind of elements of secrecy, which just happened by dint of government being complicated, right? So they kind of don't really fit into the kind of frame of efficient secrecy. There are various other examples why I kind of drew off the US case that I went into more detail in the chapter.
And actually, that made me think that maybe one of the readings that we should look back at is Posen's Deep Secrecy reading, because to sort of reread that in light of some of the things that you're talking about, in light of some of the conversations we've had over the years, perhaps there's a real sort of chunky piece of a substantial critique now that can be levied at that. Okay, so I don't know, Robert, are you able to, oh, you've put it in the chat. All right, so I will read out, unless you want to come in, Robert, I'll read out your questions. No, okay, so two questions. One, where might something like Operation Legacy play in your book and research? So Operation Legacy was the British Colonial Office's destruction of documents and information from colonial projects. So that's the first question. And then I think he has another question.
Okay, so I mean, so this is specifically in relation to the Mau Mau uprising, correct? Where they essentially hid files in a corridor so that it wouldn't be sent off to the National Records Office to be part, because otherwise it would have been captured by that, right? As well as then, so that was also both the documents that were in London as well as the substantive destruction of documents in the states themselves before the independence rulings came forward. I haven't dealt with it in any detail in the book, but I suspect I would imagine that it would fall in the overlap between esoteric secrecy. Sorry, I forget that Zoom does that thing if you put your hand up that it makes you wave. Somewhere between esoteric secrecy and operational secrecy. So there may have been a sense in which at one point it could have been covered by some justifications of operational secrecy, although I think that might have also been quite questionable. But also the esoteric secrecy is kind of like one of the arguments. It tends to do this pulling, right? It tends to pull everything further away. So it tends to say it's far more cautious, it's far more risk averse. It tends to imply that if you're not in the realm of the insiders, you're not entitled to know or even review it. It also kind of makes reference to how things like the principles of cabinet secrecy work, for example, where it takes us forward in that direction. Does that give a sufficient answer?
Yeah, thumbs up. Did you want to ask your second question, Robert? Yeah, maybe he's just typing. Okay. While he's typing then, do we have any other questions? Is anyone else keen to jump in? Otherwise, I'll pitch another question at Lydia myself. Okay, so Lydia, I want to know about whether or not, one of the things you talk about the temporal a little bit as something that we need to explore and talk about a little bit more. I was really struck by the sort of, I think the question of relative versus absolute when we're talking about ideal types and where again, this is kind of a thinking about how the UK sits compared to other states in the global international liberal order. Would you, again, it's perhaps super unfair because you're not necessarily doing a comparative piece of work, but I think thinking about, again, selfishly thinking about how this fits into a broader context of state secrecy practices more globally. I think the way that you're talking about it is that there is an absolute way to be. It's a very sort of, I guess, there's a lot of normative sort of positioning that there is a way that a state is liberal and democratic, and a way that a state does maintain its secrets. But is there, if you think of it as a more relative rather than an absolute, is the UK, where would the UK position itself on a scale of heading towards that ideal type that maybe you have in your mind? Is there another state that's perhaps doing it better? What are they doing better? Is it possible even to do it better?
Do you mean an ideal type of being liberal democratic, or an ideal type of maintaining secrecy?
Either one. Like I think it's real. It's interesting to think about what both of those. Well, maybe not the secrecy one. The secrecy in connection with the practice of liberal democracy.
I think it's interesting that that you kind of the way in which perhaps I framed it, or perhaps the way in which I've summarized it, implies that I'm kind of working towards there being such things as kind of sort of an absolute ideal in relation to liberal democracy, because I think actually a lot of the work that I end up doing is saying that, well, that's what all these theorists are kind of ending up doing, is presenting everything as if somehow, even when they're accepting that they need to do better work to understand what equality or the kind of like egalitarian demand might mean, that they're still doing so in a way that doesn't really account for the elitist based practice that is operating within their conceptions of liberal democracy. So, um, you know, governments always want to present themselves as far more liberal and democratic, and kind of therefore upholding their own legitimacy. But actually, most of the time, they're doing that in a really fairly po-faced manner, right? They're not necessarily actually enabling structures that engage with this. So the UK, particularly when I'm focusing on what it did with the Investigatory Powers Act 2016, it presented that act as a world-leading example of regulatory transparency. And it isn't, frankly. Like, it's a dense act which has had numerous challenges to it, both in the UK courts and in the European Court of Human Rights. It has been shown that it is, in fact, incredibly intrusive, and it enables the kinds of things that everybody was so shocked to find from the Snowden revelations. And so I think in many ways, it was always a kind of relativist positioning that was being undertaken about what our accounts of liberal democracy are. Now, of course, that's slightly unfair given that we know that, say, Rawls's account, even though it isn't presented in this way, must largely be focused on the kind of constitutional structure that exists in the states because of the way in which there's a kind of further codification that happens. And we lack that in the UK, even though we have a lot of moving towards that, even in a kind of historical frame. And so really, I think what I was sort of trying to get at is that even when we had the kind of narrow focus on things like the Official Secrets Act, and aren't we doing so well because we've updated them and we've been clear about what these laws are doing, that actually it was all part and parcel of the same continuation of overall secrecy that has long existed in the UK. And that really part of my argument is that a lot of the kind of ideal focused liberal democracy needs to do a better job of reckoning with that, because it hasn't, except when you look at someone like Sidgwick, who basically is the kind of total epistocratic kind of form of democrat, where he says, well, you know, the average person isn't really entitled to know anything anyway because they're not sufficiently educated, even though they might be in a kind of more kind of radical reforming frame themselves. So like normative positioning, who does it better? I'm not entirely sure anyone does it well, because I think what we often do, and this is another piece of work that I'm doing separately, is kind of largely have arguments against radical transparency, right? But nobody advocates for radical transparency, like, but it's easy to have an argument with it. Whereas we're kind of having we are led often by the kind of concerns about the kind of wider concerns about what national security is. Like, it's used as a kind of way in which to say we need to be consistently thinking about risk and fear, as well as that being our frame in what we do. And that's now become far more at the forefront than concern for upholding liberties, upholding rights, and upholding like democracy as a broader idea, whether that be representative or deliberative.
The illiberal has come to dominate more than the liberal. Right. So sorry, Robert's dropped some things in the chat. So in response to, I think, your points, and I just want to make sure that it's not just me sort of talking today. Illiberal shifts in democracy. So populists and other recent nationalist movements have I think, claimed to be critical of liberalism. The reaction, if you will, is to condone a form of illiberal approach to government, complicated further by anti-establishment actions, right wing or far right. So if this makes any sense, what might a state that leans more into illiberal shifts in democracy be? Oh, so I think, so Robert, I guess your question is, like, how would it be even more illiberal than it is now? I don't know if you can drop into the chat if I've understood your question properly, or maybe Lydia, if you've read it, if you are able.
Yeah, I'm just trying to think it through. I mean, obviously there, you know, like, I think it is evident and clear that we have had a substantial shift towards more illiberalism, and that there is a concern sometimes when you are presenting critiques of what's going on in liberal theory, that you might be playing into the hand of that kind of anti-establishment form. If that is what I think your question is directed at, I'm not entirely sure. I think in really, like, you know, that's the kind of conversation we have about, in comparison with, you know, kind of voting that is kind of pinch your nose and vote in the way that you think would be important. And I think that does a disservice to looking at the more critical ideas, as he put an update in.
Yeah. I think he's, yeah.
More, perhaps,
yeah.
Liberal forms of democracy are possible. I mean, are illiberal forms of democracy democracy? I think that's the kind of concern I have. I mean, like, in the sense that I think that there is a sense in which majoritarian representative democracy might not be terribly liberal, or vice versa. Like, that I'm not entirely sure we've got, and that's why I kind of spend quite a lot of time talking about how both liberal theory and democratic theory are really quite fickle categories, right? We like to hold them up and say they're great and they're wonderful, but we don't really know what the content of them is or mean. In many ways, that's kind of what I think I've found myself in my work doing, is spending quite a lot of time sort of poking holes in big concepts and saying, hang on, I don't think we understand this very well. And I
But if we,
think that's because when we put those shifts together, we're not seeing that our theory is doing the work that it needs to be doing because we haven't understood the problem properly in many ways.
I
That
was
sounds
going to
like a
say,
good answer.
sorry to interrupt. I think, yeah, it's at first it's getting to grips with what do we mean by democracy? And, I think specifically we're talking about deliberative, right? The sort of, so rather than the majoritarian
Mm.
forms, we're talking about the kinds where people, where different or pluralist forms, the kinds where different voices get drawn in and not and are not only dominated by an elite small minority, but are also not dominated by an illiberal majority. So that deliberative element becomes really important. Can I flip Robert's question and ask whether you've thought about going the other direction and, what would a shift towards a more liberal or back or actually towards a more liberal democratic state look like? If in thinking about the sorts of things that you've um, discussed in your book, is it
So in the sense of being more liberal in its approach to state secrecy?
Yeah, yeah, yeah. Is it removing elitist control over secrecy? Is it more transparency? Is it reducing the size of the state? Is it more education for the population? Like, have you, are we able to draw any conclusions along those lines? Clearly, there's something, it doesn't feel like that it's sitting well at the moment? Is it more oversight or different types of oversight? What would, yeah,
Um, I think it's less exceptionalized oversight, if that makes sense. So I think part of my kind of walk through the terrain is to demonstrate that there are a lot of claims to oversight in this area and a lot of claims to accountability. But because they're all slightly moderated in themselves, so one of the other examples I didn't give was the Intelligence and Security Committee of Parliament, which is particularly interesting because you would think that that would mean that it is a select committee, but it isn't. It's not a traditional select committee as we understand it in the parliamentary frame. Initially, it had a lot of restrictions on what material it could look at. A lot of its reports were redactable by prime ministers and by government, and that wouldn't be how we would understand traditional forms of accountability. Now, I have been challenged by this by other co-authors that I've written with, whether this means that I'm saying that we shouldn't have any ability to have secrecy around this, and I'm not entirely sure that is what I'm saying. But I think there's a real concern that when we have processes that don't that largely sit as another layer of secret process, so people who sit in that frame of being also covered by secrecy procedures, so i.e. they would also be governed by the Official Secrets Act, and that they're under threat if they ask certain kinds of questions, that we actually don't give people the ability to truly understand the shape of the powers themselves. Often that will be on the basis of that, we need to be, I'm trying to think of the phrase that Lord Carlisle used to use, um, like, that we are an island nation and that we need to be fearful of our enemies. But I think if liberal democracy is aiming at anything, like its kind of closed borderness, its kind of ability to see everything in a fearful frame is one thing that will pull us further away from it. So I think I would like to see accountability procedures that are more normalized, that fit within the imperfect shape of our standard court processes, of things that maybe we could be using, that we could have a Supreme Court that would be a little bit more willing to challenge the claims that are made by some of these tribunals, or so there's a specific talk about things like ouster clauses, which is where the kind of route of appeal question came, where essentially Parliament, without any debate and without any real detail on why it was doing it, wrote a clause in that said you can't appeal things from this tribunal, which really sits against most of our kind of conceptions of the rule of law. as well as our conceptions of what it means to have accountable government, right? So we're not even talking about reducing the size of the state here. We're just asking the state to uphold the principles that it says it works to. So in a kind of slightly more practical sense.
Super. Thank you. Okay. Nat, yes, Nat has a question. Um, so, to what extent do representations of transparency portray states as enlightened? How do understandings of exception within the idea of national security reproduce this sense of transparency? So, to what extent do representations of transparency portray states as enlightened? So,
I think that's a really interesting question. That's a really interesting question because I suppose it does suggest that it taps into the kind of narrative of the global north as quote unquote civilized because it's so able to say things out in the open and to do things in a way that says we can hold our power to account, and aren't we great because we've got all these wonderful processes that hold ourselves up. So I don't know if I have a kind of much more fulsome answer on that because I think transparency itself is also a very difficult concept to pin down. It's also some work I've also been doing on that in relation to the Five Eyes, especially when you come to think about it in the frame of regulatory accountability. Understandings of exception within the idea of national security reproduce this.
I think it's a shame that her microphone's not working because I suspect that she has potentially say on this.
You don't need to apologize for your microphone not working. It's not your fault. Yeah, I mean, I think so. I mean, obviously there's a large number of people working on how the kind of exceptionalization of these ideas push on and reproduce them. And also both say we shouldn't have transparency as something that's engaged in as a kind of a good. Oh yeah, no, I mean completely. Sorry, I'm just reading the second question, the next question.
So Sam has added, also relevant is how certain forms of transparency actually serve to conceal and dissimulate. So selective responses to FOIA requests, etc. Do you say FOIA? Yeah, I think.
No, we don't. We tend to say we don't tend to say FOIA. That tends to be we tend to say FOI because we don't tend to put the A on the end. It baffles me as to where these different kind of acronyms and shortenings come from. No, I mean completely. I don't know if I put that in the excerpt of chapter 2. There was a whole section in which I was talking about not just the kind of pragmatic work that it happens with FOI requests, right, in the UK. But actually, in the UK, we have 23 exemptions to the FOI Act, at least 3 of which cover national security explicitly. So you will find that there's a real challenge to get them out. And we also know that there have been manipulations of the system in relation to the timeliness requirements, in relation to the funding of the Information Commissioner's Office, who might be the one that would seek to enforce it. As well as the kind of just general misbehavior of, yeah, we have this information. We're not going to give it to you, but yeah, we have it. Which operates in a very different way to how, say, FOIA operates in the States. And that is also because FOIA has existed for substantially longer in the States. There's a piece that was written by an Australian academic whose name escapes me, all about how when the UK finally got round to enacting its piece of FOI legislation in 2000, it learned all the lessons from the things and the challenges that had been created by the various pieces of legislation in the US, in Australia, that had come before it. And so it went, oh, yeah, okay, we're going to put all these exemptions in and we're going to make our life easier. And even that didn't necessarily mean that it was any better, since we then had Tony Blair kind of loudly complaining that he regretted introducing it.
And that's also not to say that the US system is actually working.
No, of course not.
System, yeah. Okay.
But it is better than the Canadian one, which doesn't currently have any ability to release certain kinds of national security documents over time at all, right? It has no has no 30-year rule unless you go through particular narrow-winded kind of more particular subject access requests, right? This is a very confusing set of systems that's manipulated often in order to say
It's
that
a
this
shame that
information
Spencer
can't be
Spencer
accessed.
Eisen isn't here because I think he would find this conversation very interesting, given that he's working on FOIAs in Canada
Mm.
across different levels of government. Okay, so I think we will perhaps draw this to a close now. Unless, Lydia, is there something else that you wanted to add that we haven't covered today? Do you wish that there's a specific question that had been asked?
Not at all.
No, okay. Well, I think so we'll draw this to a close. Thank you everyone for coming today and for the questions. And we will see you hopefully at the Research in Progress next week, and if not, the colloquium, and if not, at the next event. So I will therefore say a big thank you to Lydia for your fascinating talk and project, and hope it, develops and is out there really soon.
It
Thank
will be eventually.
you.
Thank you to you as well, Elspeth, for having me.